I'm Jonathan Cohen. I'm a partner at nextlaw.ca, and the subject of this second video about your stunt driving 14-day impound was "It wasn't my car." So as per the new MUMS Act, the Moving Ontarians More Safely Act, you have been charged with the offense of stunt driving in Ontario. You've been given this 14-day roadside tow and impoundment, and in addition, a 30-day license suspension under Section 172(1) of the Highway Traffic Act. You have a court date, and that court date is between 2 to 6 months after your ticketing date. So the question is, I wasn't driving my vehicle. What does that mean? So let's take a closer look at the three possible scenarios with this situation. So the car doesn't belong to you. One, it could belong to a friend or family member. It could be their car. In this scenario, could apply to a parent or a car you were just driving for a friend. Two, a rental car. You rented a car from Hertz, Budget, Avis, or any other car rental, and the car was impounded for that 14 days. Or three, it's a work vehicle, and this is a common scenario for, let's say, contractors, where you're charged with stunt driving, but the car belongs to your employer. So let's take a look at it's a friend or a family member's car. This is the most common scenario for stunt driving charge regarding this 14-day impound. Clients want to know if they're able to get the car out early from the impound if it doesn't belong to the actual driver. So for example, it was possibly a father or a mother's vehicle, or even more common, it was a friend's car that you were driving home when you were charged with stunt driving in Ontario. Now, it's a very valid question and a very valid concern. Will the impound or tow yard release the vehicle earlier than the 14 days under this scenario? The short answer, disappointingly, is probably not. The law does not make any exceptions for the owner of the vehicle in relation to the charge of stunt driving. The law does not distinguish the driver from the car. They are treated as one, and the theory behind a stunt driving charge is that the driver that was charged needs to cool down. They need to have a cool down period due to their high speed and the fact that they are considered by the law a threat to public safety. So in other words, the onus falls on the driver to have to explain to the owner of the car that the car was impounded and the fees that are associated with the 14 days that accompany this charge. So there really is only one exception actually written into law, which covers a stolen vehicle, and it reads that despite the detention or impoundment of a motor vehicle under this section, a police officer may release the motor vehicle to its owner before it is impounded under subsection 10, or subject to subsection 13, may direct the operator of the impound facility where the motor vehicle is impounded to release the motor vehicle to its owner before the expiry of that 14 days if the officer is satisfied that the motor vehicle was stolen at the time that it was driven on a highway in contravention of subsection 1. So let's look at the second scenario. It's a rental car. This scenario is exceptionally troublesome for many reasons. First, the car is not yours, so right off the bat, you are liable to the rental company for the next 14 days of rental fees. Second, there may be some fine print in your rental contract regarding this. Also, in addition to the tow and impound fees, you now have 14 more days of rental fees at a minimum, and this can get very, very expensive. It is also important to go over the car before it's towed. Look at it very carefully so you do not end up with any damage to the car, which would then be transferred to you when you return it back to the rental company. Third scenario, it is a work vehicle. This scenario, it may actually put your job at risk because the company will be expecting you to return the car to work or for you to get to your job in that vehicle. It may be safest to be honest with your employer and tell them about the stunt driving charge and the 14-day car impound. You will most likely be expected to cover all the costs, so hopefully this doesn't put your employment at risk. So the question is, what are my next steps after the 30-day suspension and the 14-day car impound? Well, now you've been charged with stunt driving in Ontario under Section 172(1) of the Highway Traffic Act, but it doesn't mean that you will necessarily be convicted of that same charge. The charge is just the beginning of the legal process itself, and yes, it is a horrific start because now you have that 14-day car impound and 30-day license suspension, which happened directly at the roadside even before you even get to your first court appearance. So now is time to get some legal advice and proceed very carefully, because while stunt driving may seem like a simple traffic charge that you don't necessarily take seriously, Think about it in the context of how would you function if your license was suspended for 1 to 3 years mandatory suspension upon conviction. You would run the real risk of not being able to get to job interviews, losing your job, not being able to take care of your family, not being able to use the car for emergencies and 1,000 other reasons. And that's how serious this charge can be if you don't deal with it properly. So this video is simply attempting you to get to reach out and get free legal advice, because a law firm, a proper law firm that specializes in stunt driving charges, may have a strategy and a legal course of action that could prevent the license suspension of 1 to 3 years. And best of all, the call should always be free. So you can scroll down below. I'm available, Jon Cohen or Dan Joffe. We're available to take that call, and there's no obligation, but that call could change everything.